Welcome to today's webinar, Navigating Sales Contract Negotiations. I'm Cassie Pallison, Head of Content at Atrium, and your moderator for today's webinar. Before I get into the webinar logistics and introduce the speakers, I wanted to tell you a bit about Atrium. Atrium is a full-service corporate law firm that uses modern technology to deliver legal services that are fast, transparent, and price predictable. Founded by Justin Kahn and backed by Andreessen Horowitz, YC, General Catalyst, and more, we are trusted by nearly 400 of the top startups and hypergrowth companies in and outside of Silicon Valley. Now on to the logistics. This webinar will roughly be 45 minutes of content and Q&A at the end. You can submit your questions at any point during the webinar on the left-hand side of the screen. Today I'm excited to be joined by Steven and Catherine. Steven is Atrium's VP of Revenue, and Catherine is Counsel at Atrium. I'll let them introduce themselves a bit more.
Hey everybody, thanks for taking the time to listen to this today. I hope it's really valuable. As Cassie said, I'm Steven Boone. I'm the Vice President of Revenue here at Atrium, so I run the sales, marketing, and business development teams. Many years ago, I actually went to law school, and I think that's where I developed my love for this profession, and it's fun that I get to do it again at Atrium, but I actually never practiced. I went right into the world of selling enterprise SaaS deals, and I was at this company called Bloomreach for about the last 5 or 6 years, and I've kind of seen the story that we're going to talk a little bit about today, and I see with my clients all the time here. We were a scrappy little company. We wanted to do everything it took to get sales deals done. We didn't care whether it was on our paper or theirs. We didn't really know how or when to get legal involved. And eventually we realized the mistakes we'd made, and then we started running a real, well-oiled sales machine with 50 plus outside reps all over the world. And I'm very grateful to be at a company now where I can help people maybe not make all the same mistakes I made before.
Yeah, and hi everyone, my name is Catherine. I'm, like Cassie said, I'm counsel at Atrium on the technology transactions team here. I advise our clients on IP issues as well as commercial contracts matters as they grow their business. And in my career, I've worked with a lot of venture-backed companies. My background is in IP and complex commercial transactions, which is what I practiced when I was back at a big law firm. And one thing that really did stand out to me earlier on in my career, especially when I was at a law firm, was that it seemed like there really hadn't been any change in the delivery of legal services for the last few decades. And the practice, as well as the industry of legal, seemed like it was ripe for innovation, both from the practitioner perspective as well as the client perspective. And so for me, joining Atrium was in part a way for me to explore that opportunity in innovating delivery of legal services. And so one thing here that we've tried to do for our clients is that instead of viewing ourselves as an outside legal advisor, we try to position ourselves as a strategic advisor as well as business partner to a lot of these companies to support their growth. And in practice, what that's translated into is trying to combine the business intelligence and the business savvy, typically reserved for in-house counsel, with the responsiveness and the expertise of an outside counsel law firm. And today really is a snapshot of what we're trying to do in that space here. And a common friction point we see for a lot of our high growth companies is their revenue growth and their sales execution. And I'm sure all of you in the audience know how hugely important that is, especially for an early stage company to be able to grow their business and get customers. So whether you're outside counsel, in-house counsel, if you're a business person, CEO, the content that Steven and I will be talking about today, I think is going to be really helpful.
Awesome. Thank you. Thank you so much, Catherine. So as we kind of look at the agenda today, you'll notice, I think, a lot about how we think about navigating the sales contract negotiation process, which is that most of the work is actually done up front. By the time you're in the thick of it and negotiating with a counterparty, all of your process needs to already be in place. So we're going to walk through today and do a couple of things. The first thing we're going to do is set the stage on really how a sales organization or how a growing business should be thinking about legal as a resource, and Catherine will walk through that. Then we're going to talk about the first really important step, which is building goodwill on both sides. How do you build a relationship between sales and legal that will allow this to be a fun experience, one that is mutually productive, and one that ultimately helps you to close a lot of deals without burning people out and making them want to leave your business. Then we're going to talk about, once you have that mutual respect in place, how do you prioritize and how do you enable people as you bring them on board or as you continuously learn about your business? And then finally, we'll talk about the actual streamlining of contract negotiation. What does a well-oiled machine look like when you're actually at the end of the quarter and you need to get deals done? And then finally, of course, we'll leave a couple minutes for Q&A at the end too. But I thought we'd jump right in. And Catherine, I wanted to ask you, what, from your experience, how do the best sales teams and the best companies think about legal as a resource?
Yeah, thanks, Steven. And I think, well, when you ask people how they think about legal, you'll probably get a different answer depending on the person. So for a business person, they might tell you that legal is a transaction cost to them. Maybe it's a checkpoint. They lob something over. They expect to get it back with a stamp of approval. If things aren't going well, legal might be viewed as a blocker to them being able to accomplish their objectives. If you're asking lawyers, they'll probably tell you that legal is a gatekeeper, they're a defender, they're advocate of the company, the last line of defense. If things are not going well, legal will probably tell you that they're a scapegoat for some of those things. But what we found is the most productive way to view legal is to view legal as a resource. And this is a limited resource similar to time and budget. And this really is a very sensible way to view legal, because legal is in fact strained by attorney bandwidth as well as your budget. So if you overspend the legal resource, this can manifest itself as in different ways that are problematic to your company. So when you're talking about overspend, if you're using outside counsel, this usually will show up as ballooning legal fees. You might get a giant bill at the end of the month that you're not expecting because you were emailing your lawyer a bunch. If you're in-house counsel and you try to use resources beyond what you have in legal, then you're going to generate a lot of internal friction because you're not going to be able to close all the deals that you wanted to do, plus all your other objectives that require legal support. And in those cases, you might view legal as a blocker. So in order to effectively spend legal, which is a limited resource, at a minimum, there needs to be first trust and rapport between sales and legal. So sales and legal needs to work as a team, and that's not really possible without a certain level of trust. So if that level of trust doesn't exist between sales and legal, then collaboration between those two stakeholders is very difficult, if not impossible. And second, you need an alignment in priorities and background knowledge between legal and sales. And this is to make sure that everybody is operating on the same set of assumptions and expectations. And when you have a misalignment in assumptions, like sales is expecting things to close in 24 hours and legal knows that it's going to take 3 days and that's not communicated properly, then that's when you get a lot of friction as well. And finally, you need efficient processes, both from a legal ops and sales op perspective. And this really is to help streamline negotiations and to help avoid wasting time and resources. And so a lot of the rest of this presentation is going to contain best practices for how to achieve each of these three objectives. And if you're able to do this, then what you'll see as the end result is a well-functioning organization, and you're able to maximize your revenue for each unit of legal spend.
Totally makes sense, Catherine. Thank you so much for sharing that. And I actually think then it's a good transition into talking about what really building the base of this organization looks like. If you are, just now getting your first in-house legal hire, or you're working with outside counsel, you're just building your sales team, or it's already really big and you're kind of coming to the table a little bit late, I think this is just as relevant no matter what situation you're in. But we're going to talk a bit about what building a good relationship or building goodwill between sales and legal actually looks like. And I'd love to start with, from my experience as a sales leader, what that means. And I truly believe that on the sales side, it takes a conscious effort to create a culture where people respect legal. And you have to show the importance of your legal team from the first day of onboarding. I think it's very easy, and there are many organizations where, as Catherine said before, that you just throw something over the fence to legal and it's their job to figure it out, and you have some crazy expectations about how fast they're going to get back to you. But I've always thought it's important to have legal involved immediately. There needs to be an explicit stage in your sales cycle that is legal review. The reps need to know that they are then going to get help from someone who is a piece of the support network to help them close deals, rather than someone who or a team that is subservient to them in any way. It is a true partnership. And I believe that the way you can foster that is basically treat them as part of the sales team. Look, we all know that in sales, you get to have your big sales kickoff where everyone's going out for a week and learning a lot, but probably also doing maybe a little bit too much partying. Why is legal not there? In some of the best organizations I've been in, the AE of the Year award went to inside counsel, because the best AEs know that they would never be making anywhere near as much money if they didn't have their incredible legal partner. The same goes for quarterly business reviews. Why do you fly in all of the VPs from all over the country, or sit down once a quarter and have everybody talk through their pipeline and everything they learned about the business in the last quarter, and not include legal? Let's include them in that, and let's hear how they even notice that parts of the sales process are broken, because I promise you that they see so much more than you think. And if you can foster that culture, you're gonna close a lot more deals. And I think the best way to actually test for that is even interview from both sides at the beginning. It is not common, I think, in many companies that in-house or outside counsel would interview an account executive, but I do think it's important, and you should be asking that person questions, especially if you're selling something complex where legal is often involved. What has their relationship been with legal before? If they don't know how to utilize this resource, or they don't know how to engage respectfully, and this goes both ways. If a sales rep has red flags for an attorney, or an attorney for a sales rep, then you really don't want that person in your organization, because it's not going to foster a culture of collaboration that helps make this resource be spent the way that Catherine said it should be. Catherine, does that kind of match your view on how sales should be thinking about legal, and what have you seen from the legal side?
Yeah, Steven, what you said is totally spot on. Legal and sales really should view themselves as part of the same team, driving towards the same objectives. And it's great when sales includes legal in QBRs, in onboarding, things like that. But even if that doesn't happen, legal should still be proactive on their end in trying to understand the business, trying to understand the objectives, and overall being a good team player. And so from the legal side, you really need to understand the sales pitch. So what are AEs selling to customers? What are the compelling points that they're presenting to the customers? How are they selling to customers? You should also understand the customer profile. So is it small businesses with no legal counsel buying your product? Is it large Fortune 500 companies with huge procurement departments that are your customers? You should also understand the use case of the product or service. And there are different use cases, such as in-app marketing, or if it's just for their internal business purposes. It's also important to understand the distinctions there. And finally, and this is probably the most important one, is that legal needs to understand the product and services that are being sold. And this isn't just, understanding what goes on the line item and what the different products are in the product catalog for the company. It requires a deeper understanding of technical features of how the product functions. And this really is going to help with legal's ability to negotiate MSAs. And I can't tell you how many times I've negotiated across from Counsel, who has just scratched the surface on the business details. Even earlier this week, I was, negotiating an MSA on it included development, and the other attorney had put in a bunch of provisions addressing joint IP. And when we were on the call, I asked him, what joint IP do you envision being generated under this relationship? And he couldn't really point to a hard piece of intellectual property that was actually going to be generated. And so those provisions came from the fear that this relationship, which contemplated, in-product use of our client's SaaS data platform, there was a fear that, hey, this is going to generate joint IP, I'm going to put in a bunch of provisions just to make sure we're covered in case that happens. And so this happens a lot. I've even done it sometimes. And it's really because many lawyers don't go deep enough into the business details, especially when you're outside counsel. And it can be hard when you're outside counsel because you're not embedded in the organization. You're coming in from an outsider's perspective. But it's really worthwhile to ask those questions and try to get a deeper understanding of how the product works. And you can even ask for a product demo, a features explanation, talk to the engineering person, somebody to give you the technical and business understanding that most lawyers don't have. And then if you're able to do this, you'll know exactly what you're negotiating for, and a lot of these unnecessary negotiations and discussions can be avoided. And then finally, the last point here, it's important from a legal side to identify who the key decision makers are, both on the sales side as well as other stakeholders within the organization. And this is especially important for legal because a lot of different stakeholders can have competing concerns. So for example, your head of sales, who's the key decision maker on the sales side, usually they might be prioritizing short-term revenue goals. But your head of product, they might be planning certain product features that they need data rights for. Maybe they have plans to patent certain technology. And as legal, when you're negotiating these agreements and you're kind of allocating risk between your company and other counterparties, you need to understand what all these competing concerns are. And if this isn't done proactively, then legal becomes very reactive. So you're just running around responding to each different stakeholder. And this actually creates a lot more friction, with legal most likely to take the blame for that. And so if you're proactive about identifying who these stakeholders are and making sure that you understand the prioritization between these competing concerns, that's going to go a long way towards building goodwill for legal within the organization.
Thanks, Catherine. That makes a lot of sense. And I love hearing people from the legal side talk about the sales process this way and trying to deeply understand product too. Because I can remember, the best attorneys I've ever worked with are sitting on a legal call or sitting on a procurement call maybe, and somebody asks a question, and when an attorney basically jumps in and starts pitching your product just as well as any sales rep, you know that you've got someone you want to keep forever. So I think knowing that it's the onus of the whole organization to enable people from the legal side, whether product marketing gets in or your sales enablement team, give them the same training that you're giving the rest of the reps. It's very important. So I do appreciate that, and I'm happy to hear it. Mm-hmm. And I think that gets to really then how do you, in our next section, how do you then set priorities for your team, and how do you ensure there's consistent enablement so that you can create a good process with the right guardrails before it gets to crunch time and you're negotiating a bunch of contracts? And the way we think about that is, I got to tell you, in a world of sales, so many of us don't want to have rules. We don't want there to be any guardrails. We want to sell anything we want to anyone, whenever, and it's legal's job to figure out, what that contract needs to look like. And, maybe that's even for a product that doesn't quite exist yet, which I'm sure Catherine has dealt with before. But I can tell you that your sales team will thrive and people will hit their numbers if you give them clear guidelines. And a lot of that is about upfront telling them what's important. You have to tell legal that, but you have to tell your clients that too. Are marketing rights something that you want in the contract, or does it get struck every single time from the deal? If you want it in there, what is it worth to you? Is it worth 5% of the deal value? Are certain perpetual rights for termination okay only with some products but not with others? Can some products or feature sets only be sold with certain solution offerings at your business or not? And I can tell you that if you don't have those rules and you don't enable your team with a clear playbook, then they're going to overuse and lean on legal to help them figure out things that, frankly, they should be figuring out themselves. And the only thing, and I wouldn't be, in my role if I didn't tell you, here's the caveat, would be also know when to break those rules. I've seen many times, hey, we only give professionalized legal support to deals over $50,000. And an example from my last business would have been, there are many times that you're selling to, let's say, a holding company, and we had deals that would be smaller than the $50,000 threshold, and we wouldn't want to assign legal resources, but your job as sales leaders is to figure out when you bend or break the rules. And in a specific example like that, it might be that you have to go through almost some enterprise level negotiation to get some 30K deal, but then that opens up the ability for you to sell just on a sales order to every single other brand within that holding company for, a total value of multiple millions of dollars. And I've seen that happen many times. So set the rules, but then also, have the right people in place who can be thoughtful about when the rules don't have to exist, and enable your legal team with letting them know why this is the case. Because I can tell you that if a Catherine got a deal over her desk that was for $30,000 when the average deal size was 10 times that, and asked for a bunch of legal support, she wouldn't want to work on it unless you told her why that was the case. So be respectful both to your reps, but also to your legal team. And my other recommendation would be just make sure that you really know when legal needs to be there. In fact, I think one of the most empowering things you can do is have a tier of reps, stratify your sales team very quickly, who really just don't need legal support, where the vast majority of the deals that they're selling never go through procurement because, hey, maybe that's a certain price threshold. And by the way, there are businesses that only sell large enterprise deals and legal will be involved every single time. But I think most of us know we probably have some sort of commercial or mid-market segment and then also a bunch of bigger deals. And I've actually noticed that you can shorten sales cycles a lot if you explicitly say, this is our MSA and our sales order. Nothing changes except the commercials in the contract, and you don't have access to legal. I promise it is empowering for your reps. And then finally, build this repository of information over time. Think of every single deal on the sales side as a learning experience for both you and legal. And you should never be going to legal with product questions that have already been answered some other time. I remember in my last business, an example was we used to get massive pushback on our SLAs. This was something that was mission critical to websites that we were selling. So, hey, if you have an SLA that's, say, 4 nines, that means your product can basically go down if it's an uptime SLA for an hour a year. And in many businesses, that's not okay. An hour at the wrong time could be really bad. The real answer for our business was actually the company that we stored and built, our cloud provider, basically, that we built our product on top of, that was their SLA. Our uptime was actually much better. It was 5 nines or something like that. But I promise you that if you don't give that information to the reps and to legal, they're going to negotiate back and forth and they're going to get into sticky situations. But I do believe that if you learn that once and then you write it down in this repository or in a playbook, then you can negotiate better. And in fact, if you're any sort of reputable business and you are this open with your clients, they will want to buy from you because you can say to them, hey, this is the real reason we have this provision in our contract, or this is why our uptime SLA looks the way it does. It's not to, cover our own butts. It's because it's, physically impossible for us to do anything better, but we promise you we'll do our best. And I think that's what great sales looks like. And this type of information gathering and sharing it with legal can help you close more deals.
Yeah, and that's absolutely right, Steven. From the sales side, communicating priorities to legal is highly valuable to providing legal with insight into, what are the objectives of the sales team and of the business and how legal can help in that. From the legal end, this also similar to the previous points, legal also needs to play its part in this enablement and prioritization. And so what this looks like from the legal side is it's helpful for legal to identify must-have provisions, and to the extent possible, they should empower sales with talking points on how to sell this and convince customers and explain to them why these are necessary for legal. And generally, must-haves are usually product features that can't be compromised or areas of high legal risk for the organization. And so, for example, if the product needs to use certain data sets or there's areas of high risk where you need to be indemnified, then legal should be proactively identifying these and educating sales as to, hey, this is why we need this. This is what it means if we don't have these. And then sales can even act as the communicator of that to the customer. Maybe they'll communicate that to the business person on the other side. The business person can communicate it to their legal counsel, and you'll see a reduction in downstream negotiation because you won't have to, freshly negotiate these issues with their counsel every single time if there's some front end understanding of why these are necessary. Another really helpful practice on the legal side is to work with sales to understand the pipeline forecast. So this is especially important when you're coming up on end of month or end of quarter. In an ideal world, every sales rep would be like Steven and have the same sales team, and information would be provided to you, proactively from the sales side. But even if this is not the case and pipeline is not, handed to you, it doesn't mean that as legal you don't need it, because you still do. If you don't have it, then you should proactively be going out there and getting it. Because otherwise, what happens when you don't have pipeline forecasting, you don't have insight into what the high value deals are, which ones are likely to close, and how that ties into revenue goals for the month or for the quarter, is that legal will most likely spend the most time on contracts that are most heavily marked up. And these don't necessarily correlate with what's going to help the organization and the business get to its goals. So it's really important to have that kind of insight into what's coming down the pipeline. And the last point here is that legal should use historical data to make predictions on the legal side. And this kind of ties into what I was just talking about for forecasting and identifying what's high value and important for the organization. And for example, if every negotiation that legal has done with the Fortune 500 takes months to close, you send it back to them, it goes into their procurement department, it sits there for 2 months before they get it back to you. Then if something like that comes in at end of month or end of quarter, if you're trying to maximize revenue and you're trying to hit those targets, then that's going to be a really useful data point as to, hey, maybe this isn't going to be as likely to close as some of our other deals. And at end of quarter and end of month, especially if you're in-house counsel, you will run into the situation where you don't have enough legal resources to negotiate and close every single deal. And so when you have predictive information and pipeline forecasts, that's really going to allow legal to make intelligent decisions that align with the organization's objectives. And I mean, I think it's pretty obvious what the theme has been so far in the presentation, is that legal is a part of the business. They're not just, a checkbox, and they really should be business intelligent and driving towards those same objectives.
Yeah, thank you, Catherine. And it makes sense. And I think you actually touched on something I probably missed, which is you have to, as a sales leader, you do have to enable your legal team with all of the information about your pipeline. I know that, for 5+ years now, my forecast call at all the businesses has been on Thursday mornings, and it takes about an hour and a half. And you get into that cadence, and you better make sure that you have a legal person there, hopefully on every single call, but preferably at least during the end of the quarter. And I've gotten some of the best information I've ever had that would affect my forecast by hearing what legal had to say about a specific deal, whether that's something that is deep in negotiation and they haven't heard back, or they heard something troubling from legal on the other side, or when one of your reps with, happy forecasting hands likes to say, yeah, this deal is committed for this quarter, the quarter ends in 2 weeks, and your legal person pipes up and goes, I have never seen the contract for that deal. What are you talking about? And I promise you that if legal takes 6 to 8 weeks and you're dealing with the procurement department or something, you're not going to get there. So thank you for thinking that way, Catherine. And then let's then finally touch on, what do you do when you do get into the crunch time? If you have a great relationship between legal and sales, if you've properly enabled people, what are some of the tips to making sure that contract execution and negotiation actually goes well? And from the sales side, for me, the most important thing would be determine all of the business points before it goes to legal. I promise you, if you think that the sales cycle for a rep ends when some business sponsor says, hey, I really want to buy this product, that's like the first 30% of the sales cycle. If you then think that you're going to throw that over the fence to then say, okay, legal, now you negotiate everything that's on that piece of paper called the contract, including all of the business terms, you're not going to be successful. Have everything from the sales side done by the time you ask legal to help you, or at least make sure that you partition whose job it is to do what piece, because sometimes these things do need to happen in tandem. But price, term, marketing rights, what products and packages these people need, professional services, all of that should be negotiated by the sales side. And yes, legal can act as a check on that, but make sure that your sales team is doing their job, or else we might as well just hire only attorneys to be enterprise reps and they can do the entire sales cycle. The second, and I think I kind of already touched on it, would be there's no handoff. There might be a sales stage that says this is when you're confirming and negotiating and executing a contract, but that never means, okay, business sponsor says I need to get legal involved now. You don't then introduce your in-house or your external legal team and say, now negotiate for me. As a salesperson and as a sales leader, you need to be teaching your reps that they are project managing and quarterbacking this entire sales cycle. And that means, prepping your legal team before every call, giving them documentation about what's happened in the deal so far, and who are the players that matter and whose decisions matter. Have you actually had any engagement with legal on the other side before? You're there on every call. You're starting every call and giving context to all of the people on the call. And you're really, again, looking at legal as a resource that is busy, really helping with lots of other deals, which would be the next point on this, which is no matter what time it is during the quarter, and certainly if you're a big enterprise business who ever gets strapped for legal, always keep a list of your top deals. I like it to be the top 15, and that spreadsheet has what is the next step, who are we engaged with, and what's kind of the expected timing of the next step. Maybe it sounds a little bit different than a forecast or maybe similar, but usually lives in a separate document that legal and sales leadership has access to. And I promise, maybe that might mean you don't get access to legal on a couple of deals because you've created your top list, but it will actually make you more money in the future. If a rep comes in at the end of the quarter and says, hey, can you help me with this, average deal size deal? And the lawyer has the ability to respond and say, no, because I'm working on number 1 through 5 right now, and yours doesn't even make the list, it will end up generating more bookings and revenue for you in the long run. And it's a great thing you can do for your legal team as well. And then the expectations piece. I say set SLAs on both sides on this slide. And what I really mean by that is it is okay to hold your legal team to really high standards, especially at end of quarter, about how long can it take to respond to something, but also have the same on your end from the sales team. It's really inappropriate to get an email back from a client or red lines and something goes directly into the rep's inbox, and then to send that 8 hours later to a lawyer at the end of the day and say you need something by close of business, or even worse, help reps understand really the timing and the expectations from the other side too, which would be, I don't know how many times you see rep says, this deal is urgent. I need to get back to the client right away. Lawyer works all night to mark something up, sends it back to the client, only for the client to fall into the procurement black hole or the legal black hole over there, and they don't send you something back for 3 weeks. If you do that to your legal team, you are going to burn them out. And it also means that they were working on something that truly wasn't urgent. And I think the better playbook you can create around what is urgent, what is not, what are my expectations for various types of agreements, and really be able to say this is, DEFCON 1, 2, 3, 4, 5 is the right way to approach this type of negotiating process.
Yeah, and that goes a long way, especially when it's end of quarter or end of month, and legal is trying to get everything out, having that prioritization and the reinforcement of the top deals like Steven talked about, that goes a very long way on the legal side. And in my experience, builds a lot of goodwill, at least between legal and that particular AE. From the legal side, in terms of streamlining contract negotiation or contract execution, a lot of what can be done are processes put in place so that you avoid gumming up at the end of the quarter or during crunch time. And if you don't have these processes in place, then things might get stuck, and then you might not end up closing a lot of deals as you were hoping. And so what we have found in terms of what are good processes and good infrastructure on the legal side, especially when you're talking about high volume sales contracts, is one of those things is to have a clear approval hierarchy for escalating issues. And this ties back into a previous point that we were talking about as to how legal needs to identify key decision makers in the organization. And this goes a step further and actually identifies which stakeholder and which decision maker in the organization needs to sign off on which issues. And so what this can look like is that finance needs to sign off on payment terms, product and privacy need to sign off on data terms. Certain executives might sign off on indemnification and other risk allocation within the agreement. But it's better for legal to proactively have on hand who these points of escalation are, rather than asking the AE to go out and get those approvals, because that's really something that would gum up the process, and the AE probably doesn't know, who the key decision makers are in some cases. And one point I would like to make here is that it's not just that legal should, on their end, internally identify who these decision makers are. It's important to not only identify these stakeholders, but get alignment and agreement within the organizations that, hey, everybody agrees that this is the person signing off on this issue. Because the last thing you want to do when you're legal is to have something signed off on by one person, send that contract out, sign it, only to have another stakeholder come back to you and say, hey, I never agreed to this, this is bad. And then again, legal is going to take the blame for that. So it's important to have a pre-approved escalation hierarchy for legal to use, and that's going to really help streamline some of this negotiation. Another best practice on the legal side, process-wise, is to keep an internal working playbook of acceptable fallback positions. So if your MSA has net 30 as your default, but and it's been pre-approved from finance and across the organization that net 45 is okay, then you don't necessarily need to go through that feedback loop every single time. And then another best practice on the process side is to keep on hand versions of common business cases. And this usually comes up when there are different products which have different uses and different risks and consequently different legal provisions. It can also vary by use case. So depending on how the customer might be using your product, they might be using it for their internal purposes. They might be using it for their own products and their customers. And if you know what the common business use cases are and how those MSAs have kind of shaken out in the negotiation, you can probably get certain profiles pre-approved. And that way, when these common use cases come up, you don't have to go through the whole feedback loop of getting approval and renegotiating these terms. And then the last point here for legal is to standardize legal ops and processes. And so it's great to get, all the stakeholders in a room and everybody agree on, hey, this is the best practice for legal and sales collaboration, which like what Steven and I talked about in this presentation. That's a great first step. But in order to really standardize these processes as practice within your organization, it's important to reinforce these processes day to day. And that can look like what Steven talked about, which is reinforcing to legal what your top priorities are, making sure that people are aligned on that to drive towards goals. From the legal side, if you keep getting terms that should be negotiated already at the business end, such as termination provisions, you need to set the expectation that, hey, I might be doing that this time, but this is not standard and not optimal in this process. So it's important to reinforce those day to day.
Awesome. Super good content there, and I appreciate it. I think I hope that the story has been kind of cohesive and helpful to a lot of the people listening. That roughly kind of concludes the pre-prepared material, but I do think we have some time, and we actually finished a minute or two early. So hopefully we can take a lot of questions from the crowd. Both Catherine and I are here to answer at your beck and call. Let us know how we can help.
Alrighty, we do have a few coming in. So to kick it off, how do you recommend, practically speaking, integrating legal into sales kickoff, especially when it involves travel? Do you call them into Zoom? I know, Steven, you've had some experience with this, especially if it's outside counsel and they're flying in when they're on the clock?
Yeah, so I do think it changes if it's outside counsel or not. It's also kind of funny because I think that by the time you're having a large sales kickoff with lots of reps and you're traveling somewhere for it, it's pretty likely that you have counsel inside at that point, or someone working with you on the commercial contract side. I think that if you have outside counsel and you're doing a sales kickoff and you have a team, it might be best to have the people who are most in touch with legal. That might be even your COO or your VP of sales to do a presentation on it. But I think the most important recommendation would be to have a presentation that is centered around legal and your learnings from legal and kind of weave it in. An hour-and-a-half presentation on your first day of sales kickoff about how to negotiate on your MSA is maybe a little painful. But the best way I've seen it done is almost every successful sales kickoff I've seen has at least a couple of big deal win stories or has a couple of clients come in, and I would make sure they weave it into the story. So the most common way I do it is, reps getting up and talking for about an hour about the full story of one of their sales cycles. And if it's inside counsel, they should be at sales kickoff. I do firmly believe that, by the way, even if they have to travel. They get up there with them and say, and this was, as we got to the later ends of the deal, the things that were difficult from a legal perspective, this is what we could have done better. This is what I liked, how this rep operated, and this is what we learned from it. So if it's a full presentation, a little bit smaller, but otherwise have, even ask that question, by the way, when one of your marquee clients comes in. What has your experience been with our legal department and the way we negotiated with you compared to other companies? That might be how I'd weave it in. Just don't forget that it is an important piece of your sales cycle, and sales kickoff is focused on enabling salespeople.
Absolutely. Okay. And Catherine, how do you best find and enable outside counsel?
So it's a tough question. So finding outside counsel can be hard, and enabling it can be even harder, especially when you're, a forward-thinking tech company. Sometimes, lawyers don't have the same technical and business savvy. But I would say there's a couple points. So first, you don't necessarily have to use the same attorney for everything. So if you're using one law firm for corporate services, you shouldn't think that, hey, I also need to use the same law firm, especially if they're very expensive, for your commercial services. And it really depends on what you need them for. And so when you're looking for outside counsel, you really, on the commercial side, you should really be looking for somebody with an understanding of your business and your industry. That can be just as important as legal understanding when you're talking about commercial contracts. And there's a lot of alternative business models out there for these types of practitioners. There's also sole practitioners and other models. So you don't necessarily have to go the law firm route. It's not the only option out there. And ideally, your legal counsel would be proactive and business savvy. But if they're not, especially if you're kind of a smaller company with limited resources, you should be going out there and proactively educating them. So give them a product demo, explain the features, have them talk to, your head of product or your head of engineering so that they really understand how the product works. And you should also tell them what you care about, what your business objectives are. What risks you are or aren't willing to accept, any specific concerns that you have. And a good attorney will ask these questions. They'll ask these probing questions to identify some of what I just talked about. But if they're not doing that, then on the business end, you should be doing that, because it'll, first of all, make the lawyer a lot more effective when they're drafting and negotiating your agreements. And it'll also help reduce the amount of time they have to spend, which will usually reduce your legal fees. And the last one kind of ties into, what was discussed in the presentation, which is you should negotiate business terms up front. So termination, payment, things like that you can handle, try to iron those out before it goes to legal, because otherwise it will show up as increased fees.
Okay, and to piggyback off that, when do you consider bringing legal in-house versus managing outside counsel?
I'll take this one because my experience with most companies is they hire legal too late. So I think if you are a confident sales leader and you're growing your business quickly, you're probably fighting for headcount, right? You probably want more sales ops resources. You want more account managers. I don't know if you want more reps because it means you have to assign more quota and you're probably taking higher numbers, but ask for legal early, especially if you have, if you're selling an enterprise product that gets negotiated a lot. Hire it earlier than you think you need it. And that doesn't have to be a really expensive attorney either, by the way. That could be a contracts manager, someone who maybe doesn't even have a law degree, who just understands deeply and has been embedded in large software organizations, helping to build almost like the legal operations infrastructure of contract negotiation. But I promise that the second you hire in-house, and it often happens like once outside legal fees hit this threshold that you think is equivalent to like what it would cost to hire a legal inside, it's probably too late because that person's going to get in and say, all of your processes are broken, right? You market internationally and you don't have any GDPR policy. There's no inbound way to get contracts done. Like everybody has authority to sign anything, and legal never reviews, sales contracts for things we're buying. There's no approval criteria and, no bank of answers for our fallback positions when we're selling deals. And so I think that A, hire early, or B, find someone that you really trust who feels as if they're internal. Because I think the operations infrastructure is what's really important. And I don't want to spend a bunch of time kind of plugging for Atrium, but I think that's how we think about it and how we sell to our clients is fundamentally the outside counsel relationship, where it could be one of many people who's engaging with you at any given time and they don't fully understand your business and their incentives aren't aligned with you. It just doesn't work. So unless you're going to assign someone dedicated whose responsibility it is to understand the product and understand the needs of that business, then don't do it. And that's kind of how at least I think we are differentiated.
Absolutely. Okay. You guys both probably have an opinion on this. So for a SaaS product, where do you not need to sign the contract, and when are terms of use sufficient?
I can take first stab at that. So the short answer is generally you will always need a contract. Whether you will need to sign that and negotiate that is a different question. And so if you find yourself, downloading, installing, and accessing a SaaS product and you didn't see a contract that you signed, it's most likely because you agreed to the click-through terms. And this usually shows up as a terms of service, terms and conditions. Usually it might be meshed with the terms of use of the website. But click-through terms are essentially the same set of terms that would go into the enterprise MSA. You agree to it by use of and access of the SaaS product. And usually these terms are highly favorable to the company. You don't really get to negotiate them. That's just what it is if you want to access the SaaS. From an enterprise level, if you're a customer with a little bit more buying power, you're a big company, you probably won't want to agree to click-through terms because they're very favorable to the provider. And in those cases, you'll see kind of the back and forth, red line negotiations and the actual execution of a document. But in the absence of a kind of enterprise contract that you negotiate and you sign, usually there's going to be a set of click-through terms. And what I've seen a lot of organizations do actually is for their low value deals, they'll automatically have those governed by the click-through terms. So those customers will not get access to negotiating the enterprise MSA, and the enterprise MSA which overrides the click-through terms, is reserved for more high-value customers who are paying more. And so yeah, short answer, there's always going to be a contract, whether it's click-through and non-negotiable, or it's the enterprise MSA, which is what people traditionally think of as a contract. That's really going to depend on the situation and the customer.
Yeah, not much to add to that. I continue to be impressed that organizations can sell things that are like 5-figure deals on a click-through. But at least my layman's thought on it is, if you're selling software that costs more than $10,000, it is very unlikely someone's going to buy that on a click-through, or that you should be buying that on a click-through. Like there's some negotiation levers when you kind of get at least to that range.
All right, the next one I think really depends probably on the type of project or transaction, but what is a reasonable SLA for response when it's in-house or outside counsel?
You probably want to hear both of our answers. For me, top deals, look, at the end of the quarter on our top deals, I am sitting next, unless I'm on a plane or something, I'm sitting next to our counsel the entire time. They're probably there with me until midnight on like whoever the last time zone to hit so that I can try to get bookings in the quarter is. And we're all sitting there having pizza at the end of the day. So the SLA is like, I'm going to turn to that person and I hope to get an answer right away. Normally, I think inside, if a deal is on your top deal list or it's clearly an enterprise deal and the reps have kind of some pull to try to get those deals done, 24 hours, close of business the next day, I think is reasonable. It's oftentimes not going to be that fast with outside counsel, unless you use your kind of urgent flag and say, please help me right now. Do you think those are fair, Catherine?
Yeah, I think that's absolutely fair. I think in-house, you'll usually get a faster response, especially when it comes, end of quarter, end of month, just because those people and attorneys are embedded in the organization. When you're talking about outside counsel, they usually have a number of different clients. And so you're just one of many clients. And so in order to really get a fast response time on something, like Steven said, you kind of have to raise your urgent flag, and then they'll take into account, their bandwidth, the actual urgency in your particular circumstances, and then they'll try to move things around and get things back to you as soon as possible. But it really depends, I think, on the urgent. If it's like, end of quarter, I need this to hit my revenue targets, that's definitely super urgent. What I would try to avoid is raising the urgent flag and then having it not actually be urgent. So sometimes, clients will say, this is urgent because I want it by the end of the day without, kind of very compelling circumstances. If you do that very many times, then the attorney is going to kind of become desensitized to that, and that's not really what you want. So the urgent flag should really just be raised when it's actually urgent.
Makes sense. Okay, this will be the last question of the session. So if you're a startup selling to large enterprise, many companies require vendors to execute purchase agreements. Sometimes purchase agreements are their terms are onerous to startups. What strategies do you recommend to mitigate some of those terms, such as indemnity, limitations on liability, ramifications?
Yeah, I can hit it from the sales side super quick, which is, I think one of the jobs, especially if you're selling to large enterprises as a smaller venture-backed startup, is to make yourself seem bigger and a lot more mature than you are, like at all times. Show people that you know what you're doing, because again, in all of these agreements, no matter what type of agreement it is, frankly, people are going to throw the kitchen sink at you if they have leverage. Look, one of the first things I like to do at smaller companies, or I ask people to do, is like have a really solid business continuity plan and a one-pager that says, this is what our product does, this is why it's important to your business, this is how much money we've raised and why we have great investors, this is how fast we're growing as a business and what other really big clients who would have, also have lots of problems if this product went down or something. I would prepare all of that. And in fact, oftentimes when you send a contract to legal on the other side, it's good to like have that one pager attached, because oftentimes they will get it and they will not have any idea what they're negotiating or like what someone on their side is trying to buy. So I'm sure Catherine has some better advice around specifically how you negotiate that from the legal side. But my experience is people want to show that they're the scrappy startup and they want to sell to first movers and stuff. Once you get beyond that person who wants to buy from you, your business sponsor, nobody cares. It's not endearing anymore that you're a startup. It's actually scary, because the first question legal or anybody else is going to ask is, are these guys even going to be a business in a year? And it sure as heck better not be something that's mission critical that we're putting on our site or in our tech stack, if they might not. So it's your job to prove proactively that that's not the case if you ever want to have any leverage.
Yeah, and that's true on the legal side as well. And this actually happens to a lot of our clients, where they're this small venture-backed company. They're going up against this huge company or a huge corporation. And they oftentimes find themselves in a position of no leverage or very little leverage. And the best thing you can do in that situation is to get more leverage. And if the procurement department that you're negotiating against knows that they're a very high value customer to you, they're probably if they know that they're a mission critical customer, then they're going to know that you don't have any leverage. Then they don't have to give your attorney anything that the attorney asks for. They have no reason to do that, even if it's, egregiously unfair. So the best thing you can do is to make yourself needed. And so, for example, if your counterpart within that big corporation is telling their legal team, hey, we really need this product. It's critical for whatever we're trying to do. We don't want it gummed up in the legal process because we need to use it ASAP. That's going to go a long ways towards alleviating kind of this, what would otherwise be a very tedious and generally unfavorable negotiation outcome for you if you're viewed as a small company with very little leverage. So getting an internal evangelist to apply that pressure can be very useful. And I think just from a negotiation perspective, understanding that even though you can kind of increase your leverage by demonstrating a business need, just knowing that this is our position in this negotiation, what are the bare minimum kind of risks that we need to cover and what we need to accept, being able to identify those and communicate them to your attorney, that's also really going to help the negotiation go a lot smoother, because you're not going to be, fighting over all of the terms in the contract. As a small organization, you'll know that, hey, this is exactly what we need. These are the must-haves, and we'll give you everything else, but give us these. And that's usually going to be a lot more effective than trying to negotiate everything in that situation.
All right, that's it. Lots of questions to get through, so appreciate your guys' time, and I think this was great for everyone. And if we didn't get to your questions, we will follow up, and the recording will be emailed out within 48 hours. Thank you.
Thanks, everyone.
Thanks.
It was a pleasure.
Mm-hmm.